So I was a little, I guess I'm a little trying to figure out, there's a lot of motions and things going back and forth on this, so I'm trying to determine exactly what we're doing today.
I think I can help, Your Honor.
Thank you.
So, Your Honor, I originally had a motion to dismiss the restraining order that was issued March 31st, 2023, pursuant to CR 60, and asked for attorney fees. When that motion was heard, the judge determined that there needed to be an evidentiary hearing before this matter was decided. So we were set over to we were given this week for the hearing. We had the readiness or the trial assignment hearing last week. After that hearing, opposing counsel brought a motion to dismiss or strike the evidentiary hearing and a motion to set over for clarification. So I guess we probably need to address those motions first.
Okay. Mr. Sanders, I believe those were your motions.
Yes, Your Honor, those were our motions. And forgive me, my voice is a little bit hoarse today. I'm kind of getting over a cold.
No problem.
So if the court's ready, I can proceed.
Yeah, I'm ready. I've read everything, and I read back through the file to try and get an understanding of kind of how we got here. So I think I'm up to speed. I do have some questions, but let me hear your motions.
So, Your Honor, I'll take this in two parts, which is first the motion to strike, and then the second motion regarding clarification. I'll wait for a ruling from the court on that. With respect to the court's previous ruling, our view is that this evidentiary hearing is unnecessary. The alleged statements that the respondent relies on were done in the context of an arbitration. He chose not to bring this matter back before the arbitrator, who would have the best background knowledge of the case and the proper authority under the previous order. If it's an arbitration, then the confidentiality rules apply. Now, at the previous hearing, the court ruled that it was not an arbitration and the previous arbitration order no longer applied. I am somewhat confused by that ruling, given the fact that the arbitration order specifically says it gives the arbitrator continuing jurisdiction. But I'm not going to argue that point at this point. The issue is that if the arbitration order doesn't apply and the confidentiality order doesn't apply, then we're in a mediation. And that means ER 408 applies, and the statements taking place and the conversations taking place that he's using as the basis for this motion are taking place in the context of settlement negotiations, and ER 408 applies. I think it's very important to place this in the context of the abusive use of litigation this case has seen. Ms. Williams outlined in her declaration, which is part of the court record, the extensive pattern of abuse on respondent's part, and that includes litigation. The respondent has been held in contempt twice for violating court orders. He used a procedural trick to receive a 50-50 parenting plan based on virtual schooling. He's actively involved the children in the litigation.
I'm going to object, Your Honor, as to relevance at this point. He's arguing that this is a 408 issue, and I'm not sure what he is now talking about has anything to do with 408.
I'm making a separate point from 408, Your Honor.
Well, I guess I'm trying to understand your motion is. I'm not sure I understand your motion. What exactly is your request that you're arguing for?
So, Your Honor, if he's the only evidence he's relying on are statements made under ER 408, he can't present those in court as a basis. Those are statements of settlement offers banned for presentation in litigation. If it's an arbitration, if we go back to the arbitration order specifically says that these were confidential proceedings and the evidence cannot be presented of what happened in those proceedings. So essentially, we can't have this choose your own adventure approach where it's not an arbitration, it's not a settlement discussion, it's just a conversation.
Okay.
The second point I was making before counsel objected was that this needs to be viewed in the abusive use of litigation context that is well established in this. Finally, the burden of proof here. He needs to demonstrate by clear and convincing evidence that he should prevail in this and that there was mistake or inadvertence or fraud or misrepresentation on the part of myself and Judge Nichols. He intends to do so at this point with only the testimony of himself and Ms. Lopker. Ms. Williams has contradicted this in her declaration. The entire basis of his requested relief is the statement, both the arbitrator and petitioner's counsel assured me it wouldn't have any effect on gun rights. So he's basing this on both alleged statements by myself and the arbitrator. If the arbitrator is not here to testify, there's only hearsay statements that can be introduced, and there's no exception that I'm aware of that would allow that to take place. They need to call Judge Nichols, or at a minimum, show why they can't call him. Even if the court accepts the alleged statements were made fraudulently, which is an incredibly high standard of proof to meet, he cannot demonstrate why he wasn't presented or why he was denied a full and fair hearing on this and the ability to present evidence. There was no diligent effort to ascertain the accuracy of the alleged statements he relied on. So, Your Honor, at this point, I just don't see how they can meet the clear and convincing burden of proof if they don't intend to call me and if they don't intend to call Judge Nichols at this point.
May I respond, Your Honor?
Yes, please, go ahead.
There's a lot of issues going on here, Your Honor. First of all, counsel's motion to dismiss was denied at the last hearing. Procedurally, it is not properly before the court. If he had a problem with the hearing ruling in August, he should have brought a motion for reconsideration. The ruling from the court was that this needed to go to an evidentiary hearing. At this point, although I will address him, his arguments as far as anticipated testimony are premature. I will indicate for the court that this is not an issue for arbitration. That was ruled on by the court in August when the motion for to dismiss was denied. The only issue for arbitration when that occurred, Your Honor, was child support modification. And as far as a burden of proof and counsel arguing that it cannot be met, the court has already ruled in August that there needed to be an evidentiary hearing to make that determination. So there are no declarations here. This is an evidentiary hearing. With regard to the motion to dismiss again, since we're, I guess, arguing this again, 408 only applies to offers of compromise. It's not an issue here. Whether a restraining order affects gun rights is a matter of law. You can't negotiate around it. And evidence is not excluded under evidence rule 408 if it shows lack of good faith. Obviously, giving misleading information to a pro se litigant, I would certainly argue is a lack of good faith. ER 408 doesn't bar evidence when offered for another purpose. We are not, the purpose here is to show that there was a CR 60 violation. There are no hearsay statements. And again, this is a premature objection. The statements are not being offered to show the proof of the matter asserted. They're not being offered to show that the restraining order in this case does not affect one's gun law rights. It's actually to show just the opposite, and hearsay does not apply. So at this point, Your Honor, I would just ask that you deny the motion to dismiss and we proceed with the evidentiary hearing. Thank you.
So, Your Honor, if I may briefly be heard.
Let me ask one question, and just so I understand, were these arguments made to the prior judge about a dismissal of this?
Yes.
So, Your Honor, my understanding, and I if I'm wrong on this, I will stand corrected, but my understanding is that both motions were set over for the evidentiary hearing. My understanding is that the motion to dismiss filed back in August by my client is still properly before the court. I have the clerk's minutes up in front of me. I'm not seeing anything that says that the motion to dismiss has been denied. I'm not aware of any order that the motion to dismiss was denied. If I'm mistaken, I will stand corrected and beg the court's forgiveness.
Just looking back, it looks like Rich Warning heard this, and I don't have a specific, it doesn't have a ruling on it, and there's no order from that date that I can see. Okay, well, yeah, we'll go ahead with your response at this point.
So, Your Honor, the issue here that it's not hearsay, that it's not the truth of the matter asserted is somewhat spurious in my view, as he says he only relied on these alleged statements to agree to the extension of the restraining order. If that's not the truth of the matter asserted, I don't know what is in this particular case. Those are hearsay statements. He can't present what he says Judge Nichols said, absent a showing of why Judge Nichols can't show up here and testify as to what he actually said.
But that's a separate issue as to whether or not he's available or not. Okay. So you made a couple of comments, and I'm just trying to understand this. You said there was something someplace that said that the arbitrator had some authority that remained.
That was definitely rolled on in August, Your Honor, as counsel represented that arbitration agreement does not apply and that the court has jurisdiction, and that should be in the clerk notes.
That was the court's ruling. I will say I'm confused by that ruling, but that was the court's ruling.
Well, I mean, the order of child support doesn't contain any language that continues the arbitrator's authority to do anything. There was no transfer to arbitration when the motion for modification of support was done that I can see. And there's no, I mean, the stipulation that was filed having to do with the original dissolution was done, I looked at that was back in September of 21. And then when I looked at the decree, which was done May 3rd of 22, there's a specific reference to ongoing authority having to do with disputes over distribution of real property, which is a personal property, because that's a common thing where a court will maintain jurisdiction if you haven't got an itemized list of stuff. So that was the only continuing authority that the arbitrator had that I saw anywhere. Unless I'm missing something. I went through the decree, I went through the
You're not missing anything, Your Honor, and that was the ruling of the court. So that issue is resolved at this point.
So I guess when I looked at, I was trying to understand how we got where we got. There was a petition, or I believe a petition to modify child support that was filed.
Correct. There was never a petition to extend the restraining order filed or served.
There was never one filed with the court. It was served on the triple LT, and Mr. Rice, and they were aware of that. That is included in the exhibits we submitted with our motion to dismiss. So this argument that he was unaware there was a motion is not accurate.
That a motion for what?
To extend the restraining order.
Okay, well, that was filed with the court, so the court wouldn't have any jurisdiction to do that.
But the arbitrator did.
No, the arbitrator did not.
Why would the arbitrator have any jurisdiction to do anything? There's not been an arbitration agreement. That's what I'm confused about when I'm trying to read through how we got to where we're at. Because there was a petition filed to modify the child support, and I've got that in front of me. Just a minute, I had it a moment ago. So that was on December 9th, that was filed. And then and I'm just going back to what's in the court file. And then on 3/29, there's an order of modification. It was never referred to arbitration. I mean, parties can sit down with whomever and agree to negotiate, but the child support, or the order of modification, was signed by Commissioner Nelson. The order of child support, which was filed the same date, March 29th. And that was signed by Commissioner Nelson. I'm assuming these were agreed, so they were just done ex parte. And then there's a restraining order that was filed 2 days later on the 31st, which says it was ordered by the arbitrator. And then it was countersigned by Judge Bassett on the 30th. Well, it looks like the arbitrator didn't date it, so I don't know when that was signed. But what I'm trying to understand here is I don't know where that restraining order comes. There was no response filed to the child support. And there was no motion to extend, which would be required by the statute. So I guess I don't understand how the restraining order got there.
So,
You're
Your Honor,
accurate, Your Honor.
Your Honor, I would need a few minutes to go through and recap the entire procedural history of how we got here. But my understanding was that Ms. Lopker and I agreed to arbitrate the child support order. We proceeded on a motion for contempt as well. This is not a pick and choose availability of arbitration here. These were issues before the arbitrator. The arbitrator issued a ruling. He had an opportunity to review the order. He agreed to the order.
What I'm saying is the arbitrator never had authority to do anything unless, except as some sort of, there was no submission of this to arbitration by the court.
That's correct. And without the petition or the motion to extend the restraining order, nobody had authority to sign off on it, Your Honor.
Except he agreed to it, Your Honor.
Well, I guess procedurally, my question is I don't know whether the court at the time that order was signed, this was presented to Judge Bassett on March 30th, this last spring. And again, I assume that was done ex parte, just came back through the court, and there's no hearing notice, so I assume those all came in.
So, Your Honor, I would refer you to the actual restraining order, which in Section 4 findings says this restraining order is issued based on the ruling of arbitrator Judge John R. Nichols, retired, pursuant to the stipulation and order for arbitration entered in Cowlitz County Court, September 8th, 2021. By agreement of the parties, Judge Nichols replaced Judge Ruley, retired, as arbitrator. Arbitration was held on December 21, 2021, with a subsequent post-decree arbitration was held on February 10th, 2023, with both parties and their legal representatives present or participating virtually. With the exception of the replacement of the arbitrator, all other provisions of the stipulation and order for arbitration remain in full force and effect.
Well, it would have had to be in effect to remain in full force and effect, and it ended when the final decree was entered.
I don't believe that's accurate, Your Honor. Let me check the findings.
Well, the only thing I could find in the decree is that the arbitrator retained jurisdiction to sort out personal property issues that might arise because there was not an itemized list of personal property. Unless I missed, again, I looked through the decree. Let me look at the findings. The arbitration had to do with the dissolution.
Mm-hmm.
Just looking at the decree. That was the spot that I noticed there was some language.
I mean, Your Honor, I would point you to Section 5 of the stipulation and order for arbitration. The arbitrator shall have the authority to hear all issues regarding the matter, including motions and discovery. The arbitrator shall have the authority to award any remedy or grant any relief that would be available to a superior court judge in the state of Washington. My read of that is that includes anything post-decree.
And Your Honor, that was not the ruling of the court in August. Specifically, that was not the ruling of the court when we were here in August. That argument is gone. And it's already been decided by this court. In addition to that, Your Honor, I mean, even if opposing counsel wanted to try to argue that again, which again, it's inappropriate, a motion for reconsideration would have been appropriate if he was challenging that ruling. This is a new issue. This wasn't an issue that was in the preliminary divorce.
I mean, the stipulation would give the arbitrator the authority to handle the dissolution and anything attendant to that. And that other than, and again, I'm not finding the language, but there was some language in the decree I thought that talked about the, not finding it now, but there was some language that talked about division of the property, or I mean, unresolved issues out of the decree that may not, which would have been appropriate. That would be normal for a court to do that. But that would, here it's under paragraph 20. And it's on the next page, on page 8, the top of that. Should a dispute arise between the parties, they shall submit the conflict to the Honorable Judge John Nichols, retired for termination and arbitration. That is specific to that paragraph of to facilitate the exchange on the personal property, because obviously there was no list included. And if that language were at the bottom of the order, and there is language at the bottom of the order, but it talks about the fact this was done by agreement through Judge Nichols. Talks about when the arbitration was held. Basically, the arbitration resulted in this document, which he then signed off on April 11th, which at that juncture would have been the end of his involvement unless there were issues having to do with that personal property distribution. So 6, 7, well, 8 months later, 7 months later, we have this new petition with a new summons filed. And then all I have is just what appears to be an agreed order of modification, and then a restraining order that kind of springs out of nowhere.
So, Your Honor, I mean, I can clarify more on the arbitration order. I just want to make sure that I'm proceeding correctly here. I don't want to argue things that the court has deemed already ruled on, because the arbitration order does make several references to things that would indicate to me that it had the arbitrator had continuing jurisdiction.
And Your Honor, both counsel and myself agree that we already have an order from this court on this issue saying no.
Well, I mean, I think the other judge previously ruled on that, but I read through the whole arbitration agreement, and the arbitration had to do with the dissolution.
Correct.
If there was another agreement to arbitrate, there would have been another stipulation, or I mean, there could have been an order transferring to arbitration from the court, which wasn't. And again, the order of child support doesn't appear to be at issue here, so that sounds like there was a filing. Everybody agreed to whatever the change was. But what I don't understand is I've got a restraining order that was issued March 31st, for which there was never any request made to the court, which under the statute would be the normal process.
Correct, Your Honor. That's why we're here on a CR60 motion.
That's not accurate, Your Honor. That's not the basis for their CR60 motion. And I think it's evident from really reviewing the pleadings. This is a new argument.
Well, I understand the argument that's been alleged is that there was some misleading in the getting of this, and it seems to me, and whether that's accurate or not, I think there is some. What concerns me is we got here with an order, a significant order, which very well may be appropriate given the history of the case. I don't know that because I don't have a hearing that was done on that. But if I look at CR60, which let me get to that real quick here. What this really falls under is the issue of irregularity in the proceedings. Because frankly, the arbitrator didn't have the authority to do anything. I mean, you guys can sit down with anybody you want and mediate something, which is fine. People do that all the time. But under this, the protection order statute, there's some, in order to do a renewal or an extension, there's a process that's set out for that. And I guess the concern I have, and I think, whether or not, if you look at a petition to review or to renew a protection order, I mean, there's specific language in those petitions that advise people of circumstances, and that clearly is not how we got here. I don't know how we got here because it's not in front of me really, but let me get to that here just a second.
And Your Honor, that was in our pleadings as part of our argument that there was, it wasn't properly before the arbitrator. And it was presented to my client as if the arbitrator could make a decision, and that's not the case, which is why I cited the CR 6011 for any other reason justifying relief. You may be correct that it was irregularity in proceedings. That one's just kind of a different because it was arbitration.
I'm just looking for the form document on the renewal. I know I just signed one of these things a few minutes ago to set a hearing on one, but so I don't have that in front of me. I'm just looking at. It's very odd. I know they just changed a bunch of forms, so I'm hoping that is where it needs to be.
Your Honor, I'm just now looking at the screen. Ms. Lopker is here. If we're going to proceed with an evidentiary hearing, she's a witness, and I would move to exclude her from the pre-hearing proceedings.
Any objection to that, counsel?
I don't think so, Your Honor. I'm not even sure if we're going to get there at this point.
Ms. Lopker, can you hear me?
Yes, Your Honor.
All right. I'm going to put you back in the waiting room, so if you can just sit tight there until we decide exactly how we're proceeding. So if I can just have you just sit there, and we'll be back and get you in a minute.
Okay, thank you, Your Honor.
Thank you. Thank you for calling that to my attention, counsel. So, okay. Uh-oh. That didn't work, right? Something happened there. Well, what I guess here's my concern, frankly, is when you do a renewal, there's a specific form which includes some information to the respondent, much like a summons would be in a dissolution, and a petition that sets out the impacts of certain things. And again, I don't know specifically how this ended up, and that's obviously what's being raised as an issue. Let's see if that's it here. Okay, here we go. This is form number PO 0586. That's the order renewing. Okay, let me back up a little bit. Motion. PO 50 should be the motion. And that's the one that gives the basis and the allegations as to why there would be an extension. And then there's an order setting hearing, which is PO 054, which, and again, this is, I think, the important one, because this starts out with protected person has filed a motion. There's warnings to the restrained person as to what happens if this goes through, sets a hearing, how to attend clerk's action, service notes. So that's essentially serves to some degree the function of a summons. And under the statute, that can be filed anytime within 90 days of the termination of the hearing of the underlying order.
So, Your Honor, I would just point the court to our August 1st submission, Bates page 53, if the court can pull that up.
I'm sorry, your August 1st submission?
Yes, August 1st submission. It's the arbitrator's ruling, support, and contempt.
Are you talking about page, did you say 53?
It's Bates number 53. So, Your Honor, I would just point out to the language, the parties and their respective attorneys appeared for arbitration before Judge John Nichols retired February 10th, pursuant to a stipulated arbitration agreement approved by the Cowlitz County Superior Court concerning issues regarding child support and contempt. Contempt included the request for the extension of the restraining order. And the restraining order is specifically addressed on page 2, paragraph 4. The parties have agreed to extend the existing restraining order for the maximum length of years. I'm looking
for the document, counsel. So
okay. I apologize, Your Honor. Let me know when you're there.
It's Bates number which?
53 and 54.
Okay, I see that. I see that. And I guess, and I had a big flag on that. And where is that stipulation?
The stipulation was made informally, Your Honor. There's no formal thing on that. I will be
Well,
candid with the court on that.
Here's the problem. That says it was specifically approved by the court. So an informal agreement is not something approved by the court. I mean, this was never officially sent to arbitration. So the arbitrator didn't have arbitration powers.
So he would not have arbitration powers over the petition to modify child support either.
I would think that's accurate. Or the contempts. I mean, we never approved a stipulation to go to arbitration, even though that document, because it's not anywhere in the court file.
So my understanding of this ruling is that it refers to the September arbitration order, September 2021 arbitration order. So I would argue that's an incorporation by reference.
But that order wasn't still any good. That was an order for a different case.
That wasn't the ruling of the court at the time. The court only made a ruling on that as part of this motion.
The court didn't need to make a ruling. You need to have an arbitration order that was valid. So I don't know what the arbitrator, I don't know where this came from. So again, let's assume for discussion that the arbitrator had we all agree we're going to go back to that agreement, which when we're going to reference that, all the same terms, and then we'll let you do this. That has to do with contempt and child support. And it says there the parties have agreed to extend the existing restraining order. The specific reference in paragraph 1 of that case is that appeared for arbitration before Judge Nichols pursuant to a stipulated agreement. Let's say that other ones, we're going to consider that valid, concerning issues of child support and contempt.
And the contempt motion is included in there, and that includes the request for the restraining order. That's Bates 48 through 51. It's in paragraph 6.
And I don't know that you can ask to extend a restraining order, Your Honor, as part of contempt.
So I guess my question for you, Your Honor, is if he consented to arbitration on the child support issue, why would he not consent to arbitration on the other issues? And why would there not be a duty to him to specify that he did not agree to arbitration on the other issues? That seems like a fairly reasonable implication given the factual circumstances here.
Well, and Your Honor, I would say that the arbitration, mediation, whatever, at least there was a petition for child support that was before the court that the parties could sign an agreed order and file. The same is not true for their motion for contempt, which was never filed, and some petition or motion to extend the restraining order, which wasn't filed at all. Apparently, they put some language in a unfiled motion for contempt.
Because the parties agreed to arbitrate. Why would we file something with the court when we agreed the arbitrator had the authority to do so?
And I would indicate that the arbitrator, by agreement, even under mediation, might have had the authority for child support since there was at least a petition or a motion to modify that, but nothing else. There was nothing else before the court to be decided.
But both parties were reasonably operating under the assumption the court lacked the authority and jurisdiction under the previous arbitration order.
Well, that would fall under the mistake or portion of CR 60. I mean, this case is a mess.
No argument here, Your Honor.
There was no contempt motion filed with the court. So the contempt, even if the arbitrator were there, he could not issue an order of contempt without some sort of a contempt motion having been filed. I think an arbitrator could handle a contempt motion if it was referred after being filed with the court. But I mean, I don't even have any information that he was ever served a motion for contempt. I assume he was because it was probably talked about.
There was no personal service of any motion for contempt, and
It
obviously
was exchanged via email between myself and our office and Ms. Lopker. That I will agree with.
Well, and Ms. Lopker doesn't have a notice of appearance in. And so I'm not sure even if she were to get that, if that in of itself would be good service.
it would require personal service. So without an agreement, it would not be, Your Honor.
Well, I don't know that, didn't she sign off on the original petition to modify child support? I don't have that in front of me, but.
And again, even if she did counsel, that requires personal service on the client.
Well, the child support modification. Yeah. I don't know if that was ever served or not. I mean, it was, but it's not. I don't have a document. I mean, that's really a separate issue. That was at least filed with the court. And I think it's not uncommon. We see documents filed and then there be an agreed order of modification.
The summons they filed, or the summons I have a copy of, Your Honor, indicates that it's to be served on the LLT and gives her address, Vancouver, Washington. So I don't think a notice of appearance is technically speaking necessary.
I see what you said. That's okay. I see. I'm backwards here. So that was filed by her, the motion for the petition to modify. It doesn't have email as an optional as a service in that summons. Well, here's again, like I said, procedurally, I've got questions about jurisdiction for everything on this case. I'm not sure that an evidentiary hearing is going to help all that much. My thought is what probably needs to happen is it's clear there's an order of, there's a restraining order in place currently, which was signed off by agreement. I believe that was by Judge Fassett. I don't have any, that was not done in the courtroom. That was handed to, I assume she got it in the ex parte box and signed off because everybody had signed off on it.
That's correct, Your Honor. That's my understanding, I should say.
It was signed by the arbitrator, undated. I don't know when he signed that. I don't know when anybody signed this other than Judge Fassett.
It was signed by both Mr. Rice and myself. I know that.
I don't know when, is what I'm saying. Well, I can't read that. It looks like that yours may show up if I could magnify it enough as far as the electronic.
My signature seems to indicate March 28th, but you're right, Your Honor. It's very unclear.
Yeah, it does say March 28th. So sometime, look like you signed it then, Mr. Rice signed it, I would assume either then or sometime before March 30th, obviously.
If I zoom in it, yeah, you're right, Your Honor. I only see Mr. Sanders on March 28th. In any event, Your Honor, we would ask that the restraining order be dismissed at this time. If opposing counsel thinks there's still a basis, go through the regular hearing so Mr. Rice gets his day in court.
The objection I have to that, Your Honor, would be that we reasonably relied on this proceeding and his agreement. And the fact of the matter is this order superseded a previous order that was not due to expire until May of this year. So she should still be subject to a restraining order at this point, pending a hearing on that. The irregularities in this proceeding have nothing to do with her or the factual basis, and she still feels she needs a restraining order. Now, I understand the court may need to have a hearing on that, but essentially what I would ask is consider this a petition for a new restraining order and set the matter for a hearing in 2 or 3 weeks.
Well, here's what I'm inclined to do. I think, again, this is a case that ended up here. I'm not sure how, but it's here. I've got an order that was signed by a judge. It's a valid order until it's not. My thought would be is to, and I'll probably need to do a bench order on this, is to set this onto our protection order docket for essentially a renewal hearing.
And I'm going to object to that. I agree. Opposing counsel just said that he would be willing to treat it as a initial petition. I would be fine with that because that's
let me correct my words and say renewal.
But I disagree that it would be a renewal at this
Well-
point. The original protection order expired, 6 months ago?
It was superseded by this order.
Well, here's what I think practically speaking, it's a renewal. This was done, your client agreed to it. And I understand there's a real question being raised as to what his knowledge of understanding, and that's really a separate issue. At this point, I've got an order in place. They filed they didn't file it. There was a request in the contempt motion to extend it. My ruling today is it's going to be handled as a renewal hearing. But as part of that, I think this is slightly, and the reason I'm going to do that is because I'm not going to dismiss this until we have a hearing. Because I think everybody agreed there was going to be this restraining order. It's in place. I'm not going to dismiss it absent a hearing as to whether there should be one. The concern I have is had this been done properly, there's a different standard on a renewal than there is on a new petition. What I'm going to want to see is some actual evidence as to the basis of having it, as opposed to simply being requested. So, and there's a lot of documents in the file. You probably can pull those out and just, reformat them and refile them, because these are done typically on declaration anyway. But I think she's made some allegations of some activities that she's concerned about. I think that if the judicial officer who hears the case listens to your client's response to that, and finds there's a basis going forward, then it'll be a new restraining order. And if they don't, then it would be dismissed.
So it is actually the same standard as an initial petition.
There needs to be some evidence, and frankly, I mean, this is really the only reason.
Okay, Your Honor, I'm going to object to sorry, I apologize. I interrupted you.
I'm going to leave this in place because it's in place. It wasn't. If this would have been filed as a renewal the day after it expired, it would not have been granted. It would have been handled as a new petition for restraining order. So it wasn't properly done. But I'm not dismissing it today because everybody was operating and has been operating under the assumption that there was this order.
So, Your Honor, is it going to be held as a new petition or as a new renewal? It should be as a renewal, since it superseded a previous order that did not expire until May. If she had known that this order would now be facing the procedural morass that it's facing, she would have filed to renew it, and it would have been considered under that standard.
That's a discussion between you and your client.
So it's treated as a renewal because we're extending it, that's fine for the time being, but the burden is as if it's a petition. Can we set some dates, Your Honor?
Well, no, I'm objecting to it being as a new petition. This is a renewal of a previous restraining order.
I understand, counsel, but he already ruled that she needs to show a basis.
She needs to show a basis, but she needs to show a basis under the statutory standard of a renewal, not a new petition.
In a renewal,
because she was deprived of the opportunity to file for a renewal with the court because of her reasonable reliance on this previous agreed order.
If the standard being used is a renewal, then the basis needs to be established by my client. That was not the ruling of the court.
Has the court made a formal ruling on that?
Well, I think she needs to show a factual basis that would have, and she can go back to the time of this contempt motion. I mean, I think that's appropriate, because really what we're looking at is, had she waited until it expired in May, she would have been filing a new case. Had she filed a renewal at the time that this was all going on, that would have been timely. That wasn't done. That changes the burden a little bit.
Mm-hmm.
He's made some allegations that there was a basis to grant the renewal. So, I mean, regardless of, the difference is, under the typical renewal statute, the petitioner, all you gotta do is say, I want it extended. There really is almost no proof of anything other than a desire to have it extended. What I'm ruling is there needs to be some factual basis to do that.
Understood.
It's more than just, I want to extend it.
Yes.
So
And Your Honor, did you indicate that that's from the date of the contempt motion filing?
it can go back to any time during, I mean, if it could have been used for the renewal, it can be used for this purpose. I'm sort of putting you guys back to ground zero to some degree with the increased burden that she's got to show there's some factual basis for this.
So, Ms. Jeffers, given the fact that we've just spent the last 54 minutes rehashing this with Judge Bashor, my proposal would be we stipulate to keeping this on his docket if he's willing to do so.
I don't have that docket. I may end up with it depending upon scheduling, but I can't just schedule a hearing myself on that right now.
Okay. Can we do it as a special set? My concern, Your Honor, is not going to benefit either party to rehash all things we just rehashed.
Well, what I'm intending to do is do a fairly detailed bench order that will lay out why I'm doing what I'm doing, what the expectations are, and then circulate that both to counsel as well as to whoever hears this case, which could be me. We're super short-handed right now, so I can't just schedule a special sets.
Understood, Your Honor.
Okay.
And Your Honor, can we set some dates forward and so we can get some filing deadlines? This case has just been going on for months and months at this point.
Well, I can stick it on a Monday docket. That's when we have these.
And Mr. Sanders, how long will it take you to get a filing ready?
I would say, and forgive me, Your Honor, I'm not as familiar with the Cowlitz County deadlines as I once was. It's 3 weeks, 2 weeks, 1 week, correct?
No, not for protection orders. Those,
Okay.
I just need to know. I mean, I can give you any Monday. You probably don't want to do it this coming Monday, but I'm thinking maybe the 20th or the 27th. That gives you a week or so to get some filings. And I mean, you can file almost up to the date of the hearing, frankly, on these.
I can do the 20th. I'm in trial in Clark County on the 27th.
So I can give you the 20th or I give you the 4th of December. You got a preference?
I can do either date. I obviously would prefer the later date given the situation, but I understand if the court wants to set it for the 20th.
I'm not in a huge rush. I mean, if you guys want to sort through this, a couple of weeks is probably not going to make a difference in anybody's situation.
It generally wouldn't, Your Honor. It's just that my client's been waiting. I mean, he had to
Right.
go to the sheriff's office and get rid of all of his guns under threat of felony charges. And
Okay.
this has been in the docket for a very long time.
Quite frankly, both clients could benefit from some closure on this, I think.
No,
So
I don't disagree with that. I think we need to get it resolved clearly. How about we do the 20th at 9 o'clock? I'll do an order that sets that date. You won't have to come back to court to get anything set. And I guess, Mr. Sanders, I'm gonna go ahead and say if you can have any filings done by next, let's see, where are we at here? By the 10th, which is next Friday.
well, the 10th is a holiday, Your Honor.
Oh, I'm sorry. How about Monday the 13th?
I'm in arbitration on the 14th. Could we do the 15th?
How about the 9th? Because the 15th, that only gives me 2 days to respond and gives you like 2.5 weeks. No, I don't think so. I would say the 9th. That gives you a week. I'm in trial the 14th and 15th and can file on the 16th, meet the same 1 week deadline.
Today's a Thursday. How about next Thursday, the 9th, and then the following Thursday, the 16th? And then if
That will work.
there's any reply,
That works.
any reply that doesn't raise any new issues, that could be filed. You'll need to submit a bench copy on that because after the 16th, it wouldn't make it here by the 20th.
So our materials would be due the 9th.
The 9th, with response on the 16th.
Response.
I'm going to include that in the order.
Thank you, Your Honor.
And then are we allowed reply?
You can, a reply with no new issues, but just simply replying to existing issues.
That would be due the 17th.
Um,
I'm really concerned about a 24-hour turnaround time.
you can file that right up to the time of the hearing,
Okay.
but you'll need to submit, I would say get a bench copy, which probably under that circumstance would be, send that to a court administration email address with attention to the protection order judge.
Okay.
And
And Your Honor, the request for attorney fees.
I'm going to, I think the only, and I don't have in front of me the party's financial situation particularly here, which would really be the basis. Let me take a look here just a second.
I think there's child support worksheets potentially.
Well, there's mutual requests for attorney's fees, Your Honor, and I don't see anything that would merit attorney's fees being awarded given my client's actions. In fact, I would view that as punishing her for requesting an extension of a restraining order.
I think at this juncture, I'm not gonna award fees either direction. I think this is a messy case, obviously, but I'm gonna leave it where it's at.
Thank you, Your Honor.
And then, Your Honor, just so I'm clear, we don't need to file a new petition
I think you do.
requesting.
No, there's not a new petition, but there needs to be some sort of declaration. Basis.
But I don't need to fill out, I don't know what the form number is, but request for renewal of restraining order. Do I?
I'm going to include language in my order that as to the reason it's being set, which will include.
Okay. I have no objection to doing so. I just need to know if I need to do that.
I'm not wanting to have either of your clients run up more attorney's fees beyond what they already have. So.
Thank you, Your Honor.
Yeah, I'll include in my order the basis, what it's about, why it's on. You'll just need to file declaration and any exhibits you want on either side for the court to consider.
Thank you, Your Honor.
Okay.
All right. Thank you.
I'm going to let Ms. Lobker, I'm going to bring her in for just a moment. I want to keep her completely in the dark. Ms. Lobker, can you hear me?
Yes, Your Honor, I can.
Good afternoon.
Good afternoon.
We're going to handle this case a little differently. It's going to be set over to a date on the 20th for a hearing on a request to renew protection order. You can talk with Mr. Rice and Ms. Jeffers if you need to be involved in that or not.
Thank
So
you.
we don't have anything else today.
Okay, thank you.
You're welcome. All right. Anything further, counsel? And I'm going to do this right now, and I'm going to have my staff email a copy out to both of you.
Appreciate that. Nothing else, Your Honor.
Thank
you.
Okay.
Thank you, Your Honor.
I'll do my best to have that out within the next hour here.
Thank you.
Thank you.
All right. You're welcome. And with that, we will adjourn.
Thank you.